Hey, welcome to the Conservative Caucus podcast. This is a discussion with my friend, Mark Chenoweth. He's the president and chief legal officer of the the new Civil Liberties Alliance. Mark and I served as chiefs of staff together on Capitol Hill. We've been friends for many years. NCLA is a nonpartisan, nonprofit civil rights group founded by prominent legal scholar Philip Hamburger to protect constitutional freedom from the violations of the administrative state. NCLA's public interest litigation and other pro bono advocacy efforts strive to tame the unlawful power of state and federal bureaucracies and agencies, and to foster a new civil liberties movement that will restore Americans' fundamental rights. Now, like I mentioned, Mark's served on influential legal and policy roles, but also in various branches of government. Like he was chief of staff for Congressman Mike Pompeo. He was legal counsel to the Commissioner Ann Northrup at the U.S. Consumer Product Safety Commission. He is an attorney advisor in the Office of Legal Policy at the U.S. Department of Justice. He was a law clerk to Judge Danny J. Boggs on the U.S. Court of Appeals for the Sixth Circuit. And in the private sector, Mark has served as a regulatory associate at Wilmer, Cutler, and Pickering in Washington, D.C., and in-house counsel for Koch Industries in Kansas, and general counsel of the Washington Legal Foundation. Like I say, Mark's been a friend of mine for a lot of years. We have a wide-ranging discussion about what's been happening with the administrative state. You might not know this, but NCLA has been involved in some key decisions that came out of the U.S. Supreme Court. The most interesting to me of which was the Loper Bright case, which recently got rid of what was called Chevron deference. And what this was the idea that you couldn't go to the court of law to adjudicate something that any federal agency had done in terms of regulation. The court system had for almost 40 years made preference to the bureaucratic state to determine what the final outcome or final interpretation of any rule was. And it really put a lot of businesses in harm's way, Americans in general in harm's way. And this was a major, major opinion that got rid of the administrative state. And this is a huge, huge thing. And NCLA was in the middle of it. We talk about that general issue and some many other issues related mostly to what NCLA does. It's a wide-ranging conversation on the bureaucratic state, on the overreach of the federal and state governments. And I think you're going to really be benefited by this. So make sure that you stick with us all the way through. You're going to get a lot of interesting information. And of course, go to our website, theconservativecaucus.com, to get more information. And with that, my discussion with Mark Chenoweth, president of the new Civil Liberties Alliance. Well, thanks for joining us on the Conservative Caucus podcast. I'm here with my friend, longtime friend, actually, Mark Chenoweth. He's the president of the new Civil Liberties Alliance, which does fantastic work trying to go after particularly the administrative state. I think you do a little bit more than just that, Mark, but that's kind of one of the main focuses of what you all do there, I believe.
Really the sole focus. Occasionally we'll do a little bit of religious liberty work that's outside of that, but that's a very small fraction of what we do. I'd say 99% of what we do is really focus on the administrative state.
Tell me a little bit about the history of the organization, because I'm pretty certain a lot of people listening to the podcast here, they don't know much about NCLA, but they really need to understand that it's actually a pretty significant organization that's doing a lot of things that I think people would be really excited about, but just don't see it every day.
Well, and that's why I'm so excited to share it with your audience, Jim. So we are about 8 years old. We were founded by a professor named Philip Hamburger at Columbia Law School. Don't worry, he's a law professor, but he's one of the good guys. There's still a few out there. So Philip, and some people may be familiar with Philip, he had written a book on the separation of church and state back 20 plus years ago, explaining why that concept is all messed up, and sort of had really made his name in the academy on his religious liberty scholarship. But then in 2014, he wrote a book called Is Administrative Law Unlawful? It's really a magisterial work of legal history, over 600 pages long, where he traces through all the things that colonists were complaining about with the British Crown and King George III, all the different sort of liberties that were being taken away, like the right to trial by jury and so forth. And then talks about how the modern administrative state has somehow replicated all of those evil things the Declaration of Independence was complaining about, that the Constitution was written to prevent. And yet here we are 200 years later, or almost 250 years later now, with this modern administrative state that is, we're just back to where we were before with the British Crown, where all these civil liberties are being abused. And then, so this book that he wrote was very well received, particularly by the limited government community. But folks said, well, Philip, what are you going to do about it? And he was familiar from, like, as I say, from his religious liberty work, he was familiar with the Becket Fund, ADF, some of these groups who are very active and successful litigators in the religious liberty space. And he said, well, what if I started a group that was built on that model of being a litigation firm, but instead of going after religious liberty, we focus on all these other liberties that the administrative state violates. And the folks at Becket were very enthusiastic about that. Their experience was that civil liberties, they weren't really seeing them violated by legislators. What they were seeing in the vast majority of their cases was civil liberties being violated by bureaucrats. And they said, if bureaucrats are willing to violate people's religious liberties, then Lord knows what's going on with all the other civil liberties that are supposed to be honored, but are being violated every single day in this country by state and federal bureaucracies. And so that's what led Philip to found the new Civil Liberties Alliance. We've been going strong for about 8 years now. We've been litigating for almost 7 years. And to the extent people have heard about us recently, it's probably because about a year ago, we're the organization that overturned Chevron Deference, which was a 40-year-old made-up doctrine of the Supreme Court that said that judges have to defer to legal interpretations of federal agencies if there's a sort of a plausible, if those agencies have put together a plausible or put forward a plausible interpretation of a statute. And we were able to convince the Supreme Court that no, that's not what courts should be doing. The Constitution spends a lot of real estate defending the independence of the federal judiciary, and they shouldn't be deferring to federal bureaucrats.
Well, not to mention the fact that our system of law was created, first of all, to give preference to citizens and organizations as well, obviously, to be able to mitigate disputes. Very, by the way, not dissimilar from the system that Moses set up back in the Old Testament, which was there's a system of law that's available. And when you have a dispute, find a way to adjudicate it in a proper manner. Now we've got so many things that seem to violate that principle. But one things I wanted to mention here and get your thoughts on. A lot of times in this day and age, with the federal government having such broad overreach into the lives of Americans, people bring up mostly taxes when they say, well, yeah, the colonists, they went to war with England for separation from England because for a 2% tax on tea, and they'll kind of throw it out that way. And substantively and very real, that was definitely part of it. But isn't it kind of true when you read through the Declaration of Independence, you realize, yeah, the taxation thing was bad, but that really was not the main problem that they were trying to address. It was exactly related to the types of problems that we see in the administrative state in the United States today. Am I missing something here?
No, I think that's right. I mean, we could talk about taxation without representation as well, and maybe we'll get into the tariffs case that NCLA has later. But by and large, if you read through the Declaration of Independence, you'll see Thomas Jefferson and the other authors of that document have a laundry list of complaints about the way that the colonists have been treated, and among those are and I wish I had it in front of me because the quote is great, and I don't remember it well enough, but it's to create offices to harass our citizens and eat out their substance. Well, gosh, that sounds a lot like the modern administrative state, doesn't it? To have all of these just dozens of agencies that people have to deal with if they're trying to run a business or really do anything in the modern economy. And then also the right to a trial by jury is something that the Crown was taking away and trying to try people in admiralty courts or try to haul people off to London for trial rather than try them in their own communities. And we see that happen even today, where administrative agencies try to haul people to D.C. or try to try them in places other than where they are, where they are or where their business is.
And keep in mind, that's one amongst many things that the founders put together in the Constitution and elsewhere discussing. One of the reasons we have a trial by jury of your peers was precisely because of this lack of appropriate geography, so to speak, in terms of the actual cases that were happening. That's why they wanted a jury of your peers, because implied in that was not only the geography where you're in, people in your own or at least close to your community who understand what's going on there, but also to avoid throwing people into, at that time, a 3-month journey over to England with no support group or network that they had here, which was an even worse case of it. And when you talk about admiralty courts, that actually did include, in New York Harbor in particular, this happened, throwing people onto ships, and they were cut off from their local community, and they just have a makeshift military court that they'd throw up on the ship, and it's like, okay, let me give you your due process before I, find you guilty. Due
process.
Yeah, exactly. And so, which was amazing.
Those were air quotes for the audio only portion of your audience.
Air quote. Yeah, absolutely. and that is really, really critical, because England, which is the foundation of common law that our legal system was based off of, that they always had done so well and had developed so fully, they totally threw away for the colonists for political reasons. And that also is a similarity, in my estimation, to what's happening today, because we are throwing off a system of common law through the administrative state for political purposes, because of political objectives that people want to undertake. I mean, EPA is just a great example of this, and just the regulatory state in general, where regulations are thrown out, not because Congress passed a law and said needs to be regulated, but they'll go beyond that to try to find some way to fulfill that. And I'm using air quotes again, but then to also throw in a new twist that will be a political objective. And we've seen this in particular over the climate debate, many other things too. That aspect of the administrative state is part of that. Am I hitting that pretty close to the vest there?
Yeah, I think that's spot on, Jim. And with EPA in particular, I would give you the example of some of these federal permitting regimes where Congress has, under the Clean Air Act and other statutes, given the EPA the ability to force permitting for certain kinds of industries and factories and smokestacks and what have you. But then at the same time, they might be within the permit, but the Supreme Court has allowed lawsuits against some of these same factories under nuisance theories. You're like, oh, now wait a minute. We can either regulate this under the common law theory of nuisance and, who was here first and coming to the nuisance and all these sort of common law principles, or you can have a permitting regime where the federal government steps in and says, okay, we're going to supplant that common law regime with a federal statute that Congress has approved, and here's what this permitting look like. But too often the EPA has said, well, here's your federal permit, so EPA is not going to come after you, but the private lawyers can still come after you under a nuisance theory. So, well, no, wait a minute. What's the point of the federal permitting system if it's not supplanting the common law? You shouldn't really have both of those things, in place. It really should be one system or the other.
Yeah, there's no doubt about it. So let's jump up about 30,000 feet here. I'm just curious then.
Above the smokestacks.
Exactly. Above the smokestacks, hopefully far enough into the stratosphere that that we won't, not too far up in the stratosphere, so we won't get hit by Bill Gates' jet as he's heading off to the next climate meeting that he's going to. What is the problem then? So we kind of touched on it by mentioning how the similarities between what was happening in the founding generation, and that we have we've literally rebuilt that system and probably expanded upon what was going on that Great Britain was doing to the United States at the time. Okay, so what is the problem then? Beyond just that part of the statement, what are we looking at, and what is the actual effect on the average American from what this administrative state does?
So there are lots of different pathologies that the administrative state is that you can identify with how it operates. There's 7 particular things that NCLA has identified as areas that we want to litigate in and that we have litigated in. And these aren't necessarily in order of importance, but the way I like to talk about it is first that there's the First Amendment area. And primarily when we're talking about administrative agencies, we're talking about either speech bans or speech mandates, or sometimes you'll see licensing, sort of licensing of speech, or requirements that people get advance permission before they speak about things. All of those are no good under the First Amendment. Particularly, what we've seen is that agencies like to take a shortcut, and instead of regulating conduct, which might be allowed under the Commerce Clause and other constitutional means, they say, well, it'd be a lot easier if we could just regulate speech and say, well, you got to stop talking about this, that, or the other thing. But that's not what our First Amendment, that's not what our Constitution allows. And so these speech bans and mandates are something that we have pushed back against. For example, the Securities and Exchange Commission, if you settle with them an enforcement action that they've brought against you, they have a gag rule in place that says that you can't dispute any of the charges that the SEC brought against you in its original complaint. This is even though by the time you get to a settlement, you know, and the SEC knows that some of the things, maybe everything, but at least some of the things in that complaint aren't true, and they could never possibly prove them in court. And yet the SEC insists that you never dispute the items in that original complaint as a condition of settlement. Well, that kind of gag rule, we think, is unconstitutional. So we have a lawsuit pending in the Ninth Circuit right now on that question. The second area that we litigate in is, I think of them as our Article 2 cases. And so this is places where federal agencies are exceeding the statutory authorization from Congress. Essentially, they're doing something that Congress never said they can do. Sometimes we also have what are called non-delegation cases in this category, and that would really be Article 1, not Article 2, if we're getting technical about it. Because Article 1, the very first line of the Constitution after the preamble, says that all legislative power is with Congress. And so Congress can't divest that power to federal agencies and say, oh, you guys write the laws instead. That's not allowed. The Congress is the one that has to do the legislating. And sometimes
which by the way, is probably the main nexus into the administrative state, or the expansion of it, that we know of. And a real quick clarification for people, so people know. Yeah. Article 1 powers are legislative powers. Article 2 powers are judicial powers.
Executive.
And then executive power, excuse me. And Article 3, I was getting to it. And then Article 3 is judicial powers. Yeah, that's what I meant to say. So just so when you're using those terms, just so people understand. Go ahead, though.
Yeah, that's exactly right. So in that second bucket, we have, for example, we had a lawsuit against the Bureau of Alcohol, Tobacco, and Firearms at the Supreme Court last year in a case called Cargill v. Garland, where ATF had written a rule that banned bump stocks and tried to pretend that bump stocks were part of the ban that Congress had passed on machine guns back in 1986. And we said, well, no, wait a minute. Bump stocks didn't even exist in 1986. And if you look at the language of this statute, it does not encompass bump stocks. And so, we had to fight that issue for 5 years, but eventually we got up to the Supreme Court and we got a majority of the Supreme Court to agree with us that ATF had essentially tried to rewrite the statute in a way that prohibited ownership of a completely lawful product. And so,
by the way, that they ostensibly, tell me if I'm wrong about this, since you did the actual litigation. I'm going to imagine that the legislation itself had a well-defined definition of an automatic weapon that could not have applied because, a bump stock allows something like an automatic, a rapid fire approach. But the definition of a bump stock from the legislation itself would not have qualified. I mean, all these other issues are part of it, but the legislation did specifically define what an automatic weapon was. And there's no way you could fit that definition with the bump stock. And yet they proceed anyway because of this quasi-automatic nature of what a bump stock does.
Yeah, that's right. And it was really a statutory interpretation argument. We said, look, here's what the statute says. It says automatically. Well, first of all, this is a semi-automatic weapon. It's not an automatic weapon. And so what does that mean? It means for every pull of the trigger, one bullet comes. Now, with an automatic weapon, you get multiple bullets with every pull of the trigger. And that's the difference between an automatic weapon and a semi-automatic weapon. And what Congress banned in 1986 were automatic weapons. They grandfathered some in, but there was a ban there. They did not ban semi-automatic weapons. And so the bump stock does increase the rate of fire. At least it can if, they're actually not that easy to use. But, for somebody who has trained on it and is a skilled user of the device. They're actually invented, Jim, and this didn't get a whole lot of attention from the media, but they were actually invented for people who can't really operate a trigger very well. So either because you have maybe arthritis in your trigger finger or you might have some sort of disability with your hands or something like that. The idea was, well, here's another way of activating the trigger. You can essentially hold your finger steady, and instead of pulling with your finger, you push away from you with your non-trigger hand, and you operate the trigger that way. And it's just the design of it was to help people who otherwise might not be able to operate a firearm, the disability community. And that was that didn't get a lot of attention in the from the media and the litigation.
I don't think it got any attention that I could see.
Yeah, very, very little. But the idea was, under the statute, automatically, is this automatic? Is it more than one shot? No, it's not more than one shot. And so when the Supreme Court looked at these questions, it ended up siding with us, with our client, Mr. Cargill, and we were delighted. But again, it took 5 years, and we had a whole bunch of courts go the other way between us and the Supreme Court.
Okay, so that's the second area. What's the third? You were going to go through the 7.
Yeah, so the third is judicial deference. So this sort of our Article 3 cases. We were talking about Article 3. So that includes the Chevron case that we talked about before. And Chevron's sort of the granddaddy of them all. It was maybe the biggest deference doctrine out there. But we call them the dirty dozen deference doctrines, because there's all these other ones that no one in your audience has ever heard of, probably Griggs deference and Auer deference. And I just learned about one recently, maple leaf fish deference. But all these deference doctrines have the same flavor to them. Well, maybe not the maple one. No, I'm just kidding. But they all have the same flavor. But it's essentially, instead of a judge doing what judges do the rest of the time, which is look at the law and interpret it and apply the tools of statutory construction and figure out, okay, what did Congress mean when it wrote these words? Instead of doing that, they look at what the executive branch, how it's interpreted the law, and they decide, well, is that reasonable or not? And if it's reasonable, then they go with that instead of doing the work themselves. All the deference doctrines have that flavor. And so, we think all of them are unconstitutional for the same reason. And and in fact, let me interject there, and we'll talk about Chevron in more detail as we move along.
Sure. And this may get actually a lot to the substance of Chevron, but because of the deference idea, it is a fundamental right for Americans to be able to adjudicate harm done by them, not just by other citizens or organizations, but also by the government. Like, that's fundamental to liberty. I mean, in deference, any deference doctrine takes away, you said it's judges not doing their jobs or being lazy about it, or at least not having to. I mean, it's even fundamentally much more than that. It is a power given to the executive branch or some administrative branch, some administrative group that allows them to decide in a judicial manner, as you look at it,
right,
exactly what the outcome's going to be with no ability to go into a court. It's not just that judges don't have to do their work, and they judged on it probably for that purpose, because they didn't want in part because they didn't want a load of cases coming into them, maybe that seemed ticky-tack, but it's a very ticky-tack nature of the amount of cases that can come that give deference to citizens, as opposed to allowing an administrative state, any administrative agency of any sort, just to say, hey, listen, it's up to us and you're done, which is part of probably what allows the SEC to do what you were talking about earlier as well. But yeah. Am I catching that right here?
No, yeah, you're exactly right. And in fact, you have predicted the fifth area and we come back to the fourth area, but the fifth area that we litigate in is precisely that, is the sort of the lack of due process around these administrative agency tribunals. So if you are in federal district court, then your prosecutor is separate from your judge. And you have the federal rules of evidence, and you have the federal rules of civil procedure, and you have the right to have evidence that is in the government's possession that shows your innocence. They have to turn that over to you. It's called Brady material. They have to turn that over to you. They have to. You have the right to provide witnesses in your defense. You have the right to be tried in a certain geographic location. There's all these things and I mean, just read through the Bill of Rights. They're all, most of these are right there. Brady evidence isn't spelled out there, but the Supreme Court had found that right back during the heady days of the Warren Court. But I do think it's an important one. I mean, if the government,
Miranda too, by the way, out of that court. So yeah, absolutely.
Yeah, and so you have all these rights. If you're in an administrative tribunal, Jim, you don't have any of those rights. And we have represented people. The agency knew that our client didn't do the thing that they'd accused him of. They had evidence that our client hadn't done the thing that they accused him of, and they were going after them anyway, and they weren't turning over that evidence to our client. Or we had another client who the SEC was going after, who had a whole bunch of, they'd accused him of a kind of a securities investing scheme. But they didn't actually have any complaints from any of his clients, and he had several clients lined up to testify to say, "Well, no, we love this guy, and we've used his system, and it's worked very well for us, and et cetera." And the agency said, "Well, that's fine, but if you testify, we're going to need 5 years of your books and records, and we're going to have to take a look at that if you decide to go through with your testimony." Well, Jim, in any federal district court, I don't care if you're talking an Obama judge, Biden judge, a Bush judge, or a Trump judge, any federal district court in America, that is witness intimidation. And that's what the agency was trying to do. And not to no one's surprise, those witnesses disappeared and said, well, we love the guy, but we're not going to turn over 5 years of our books and records to the government, when they're mad at us for testifying.
Which was the very purpose for that very onerous request that no court would do. They would go on the evidence and facts of the case in front of them and only dig into things like that if it's absolutely relevant to what is in front of the court of law. Have I defined that correctly?
Yeah, no, that's exactly right. That's exactly right. And that's the other thing that we've seen is at the NLRB, for instance, we had a case where we were talking to the prosecutor. That's the National Labor Relations Board, so people know. Go ahead. Yeah, thank you. That's right. We were talking to the prosecutor who was again, bringing an enforcement action against our client. And in this case, it was the Federalist and Ben Domenech. I don't know if you remember when the NLRB came after them because Ben had put something on his Twitter saying, this was after there'd been a walkout at Vox from some of the people at that left-wing website. And Ben jokingly said, first one of you that tries that here at the Federalist, back to the salt mines with you kind of thing. And they all thought it was funny. And they're like, oh, Ben, the only thing you know about salt is the rim of my margarita, kind of thing. And it was all jokey, but some jerk labor lawyer out there filed a complaint with the NLRB, and bizarrely, they took it seriously. And so we had to take that case all the way up to the Third Circuit U.S. Court of Appeals before we got a decision from Judge Hardiman saying, yeah, the First Amendment allows humor and jokes, and this is not something that should be that really should have been a federal case at all to begin with.
Put some real light on that. Like anyone, even a judge, like if that was going to be a judicial process, it should have been as simple as having the complaint go to court, set up a 15-minute hearing where a judge could easily come to that decision, but it goes through the administrative process first, which takes all that away. And again, in this case, let's be honest, for political purposes, because the Federalist is a conservative website that has conservative opinion, and most administrative officials in Washington, D.C., you and I have been around D.C. for a long time and seen this. Most of those people are of a more Democrat way of thinking and can have a political purpose to say that we found something and harass the Federalists because they are annoyed by what they think. Just like I'm annoyed by what Vox did. I'm totally annoyed by it, right? Or Mother Jones.
Yeah.
So if it was all Republicans, would they do that against Mother Jones or them or Rolling Stone because they didn't like you? You just can't do that in a free society.
Yeah, I mean, it's very clear to us that the person who filed the original complaint, this labor lawyer, was doing it in order to create problems for the Federalists, didn't like the Federalists, and wanted essentially to make we call it making the process the punishment, Jim. That's what happens too often in these administrative proceedings. And so this happened, actually, it was during the first Trump administration. There were 3 Republicans on the NLRB at the time, and they should have, I mean, my view is they should have put a quick stop to it. But when these things get down in the bureaucracy, that doesn't always happen as the way that it should. And so this case dragged on for quite a while. And but the particular thing that I was going to mention to you is that we were talking to the prosecutor in the case, and he just mentioned that, well, I can't. We were trying to reschedule something. He's like, well, I can't do that because I'm sitting as a judge that day. And we're like, I'm sorry, what? Well, it turns out that at the NLRB, some of these administrative judges, they trade off sitting as, like, you're a prosecutor one day and then I'll be the judge. And then the next day I'll be the prosecutor and you be the judge. Like, I'm sorry, what? How is that possibly due process when you've got people who share the same office trading off being prosecutor and judge? You think there isn't back scratching going on in that situation? I mean, how does any defendant stand half a chance of getting a fair hearing in that sort of circumstance?
And again, this proper separation can only be upheld within a judicial system. It cannot be properly managed, and there are too many moral hazards against managing it properly in an administrative structure. And I remember, this reminds me of, I think it was Douglas Ginsburg did a PBS series on, where we are in the Constitution, the name of which I'm forgetting, you might remember.
I don't remember the name of it, but I remember Ginsburg doing it, and I remember it was good. And it's a
fantastic series. I mean, he's a very, very even keel. He's been a conservative judge for the most part, or at least would be perceived as that, but very well balanced treatment of what's going on in our constitutional process. And he did bring up the fact that in the executive branch, we have every federal power, Article 1, Article 2, Article 3 power, some way or another is exercised through the executive branch, including police powers, which is another thing that should be separated from all of those. Well, it's an executive function, but that's all. There are limitations on federal executive power when it comes to police powers, and those are thrown away too.
Well, yeah, and there is no federal police power. There is no general federal police power. That's one of the powers that the Constitution reserved to the states or to the people, was that sort of general police power. When the FBI does express
police powers, by and large, it is in cooperation with local and state governments, as opposed to independently. They have some independent approach, but yeah.
Yeah, well, and sometimes people misunderstand what we mean when we say police power. It's not that there can't be a federal FBI. I'm not suggesting that. When we talk about the police power, what we really mean is the power of the government to police conduct, right? And
Correct.
So that's something that typically is reserved. That sort of general power is reserved to, and it's not even reserved just to the states, it's reserved to the legislatures of the states. So this is one of the arguments, Jim, we tried to make during COVID, because we saw all sorts of civil liberties being violated all the time during the COVID pandemic. You had these governors who were declaring emergencies, and then the governors were shutting down businesses and doing these. You had the eviction moratoriums. You had all these things happening under ostensibly under police power. Well, I'm sorry, Governors don't have police power under, and this isn't something I'm making up today. This has been true for over 200 years. The founders, when they talked about police power, they were talking about something that belonged to the state legislature, not to the governor. And the legislatures can't just turn that over to the governor and say, oh, you write all the rules. You decide which businesses can stay open and which ones have to close.
Right.
You decide who has to stick a needle in their arm and who doesn't. That is not something that governors are empowered to decide, but you sure wouldn't know it from the way they all behaved during the COVID pandemic.
Well, and think about this too, because the restrictions.
I shouldn't say all. They didn't all behave that way. We had
they didn't.
We had some exceptions. We had
but
some.
But it was a bipartisan problem too. Let's just throw that out there.
We sued Governor Baker in Massachusetts, who was a Republican. Over this.
And DeWine in Ohio, and my friend Eric Holcomb in Indiana. They all went way overboard in what they did. But what's interesting about this is the limitations and restrictions that state legislatures give to governors, which is emergency powers. Now, again, we can argue about how appropriate those were in these particular cases, but to the extent the legislature allows those emergency powers is quite similar to war powers restrictions that are placed on the president of the United States in the Constitution, where, then they have a war powers legislation that allows the president to do certain things, which is always been constitutionally suspect and questionable. Right. But nonetheless, they say, okay, well, if it's within these amount of days, you can take action, but you got to come back to Congress. You can't do any more. Very similar to these emergency powers that governors had. But ultimately, those are legislative questions. They are not administrative questions. And that seeped down into state policy where it showed up in its worst case in COVID, but it shows up in many other ways and has in recent American history, partly because we don't teach in schools. And it's not like Americans need to think about all these things all the time in precision. But when we teach the basic principles in schools, then you've got a populace that says, hey, whoa, wait a minute here. That doesn't seem right. And they may not remember why, but they are not going to have that. That doesn't seem right unless it didn't seem right when they were told specifically so in education.
Yeah, that's right. That reflex may not be there. Well, frankly, it wasn't there enough during the pandemic. This wasn't the first pandemic in American history. We had pandemics. I guess the last major one was in the late 1960s, and it was handled completely differently from the one that we had, most recently with COVID-19. Yeah. But let me jump back to the list that we started to go through, Jim, if that's all right with you.
Go to number 4. Absolutely.
Yeah. So number 4 is the Fourth Amendment. It's plain and simple. It's the administrative agencies like to avoid giving search warrants. They like to just give civil investigative demands, or there's all these other requests for information. There's all these other things that these agencies do where they try to get information from people that invades your privacy, or that under the terms of the Constitution would be a search of your papers and effects. And instead of showing probable cause, going to a judge and establishing their right, obtaining a warrant from a judge, and then establishing their right to that information, they try to get it in these other ways. And so we've been a big opponent of that, and trying to force these administrative agencies to play by the rules that the founders put in place in the Fourth Amendment.
By the way, there's a great scene in the movie Rear Window that everyone should watch. So for those who haven't seen it, Jimmy Stewart has his leg broken. He's stuck in his New York apartment.
Jimmy Stewart. Jimmy
Stewart. Yeah. By the way, from Indiana, Pennsylvania. I'm from Indiana, Jim. Anyway, but that's a different thing. Anyway, so he's stuck.
He went to Washington. You went to Washington.
Exactly. So he's sitting in his apartment, and there's a courtyard that 2 or 3 different apartment buildings circle around, and he sees evidence of a murder in one of the apartments across the way. And he's convinced of it. And, but he's got his friend who's a detective. He brings him over. He starts describing what he saw. And the guy had removed a big trunk, and he wanted the guy to go check out what he's doing with it. He says, I can't go do that. He says, well, why? Does he have a special card with the police down the way? And his detective friend says, no. Have you ever heard a thing called the Bill of Rights? He was essentially asserting the Fourth Amendment principle.
No, they don't make movies like that anymore, Jim.
They don't. But that tells you what the instinct was, because his retort back to him as well was, okay, oh yeah, here's what I'll go tell the judge. Yes, Judge. Well, my friend, who's an amateur sleuth, sitting in the back of his, but in effect, that is how flimsy some of these things are. When you talk about an administrative agency, for example, saying, oh, we're pretty sure that such and such happened, and we're the experts. This is why the Chevron doctrine is so outrageous, in my opinion, because we're the experts and we know better. And it's like, no, you got to prove that in a court of law. You just can't just come out and say someone did something wrong and begin making them pay for it. And so anyway, the Fourth Amendment thing is really important, and I'm glad you guys are working that. It's one of the most abused rights in our nation right now. It's definitely in the top 5. Patriot Act. I could spend all day talking about the Patriot Act.
Yeah, but or the FISA court.
And FISA court. The FISA court is entirely illegitimate based on the Bill of Rights, because you must be able to have both parties come at things, and they figured out a way. And we've got good people. People that are moral. Judges. The judges are moral, right? And so they're going to do all that behind there, because we've got good people who are going to make sure that this process stays good. No, that's exactly what England was saying. We're the good people, you're the bad people. And it's that subjectivity that the Bill of Rights attempts, at least, to take away. Go ahead on the Fourth Amendment stuff that you're doing.
Yeah. Well, so as an example, we had a lawsuit against the IRS in a case called Harper. Unfortunately, the Supreme Court just denied cert in this case last month. But what had happened to Mr. Harper, he owned some cryptocurrency and he had it stored with Coinbase. And the government, rather than Congress has passed a law that allows something called John Doe warrants. And what a John Doe warrant would have allowed the IRS to do, they could have gone to Coinbase and they could have said, we think that this person might not have paid their taxes on their cryptocurrency. And so what we would like for you to do, don't give us all their financial records. We're not entitled to that. But can you give us the name? And then once you give us the name, then we can go check our tax returns, for example, and look at the name. And we can say, oh, Mr. John Doe, whose identity we now know, he did declare his cryptocurrency and he did pay his taxes. Or maybe he didn't declare his cryptocurrency, he didn't pay his taxes. Okay, well, now that we know that, now we can go to a judge, we can get a warrant, we can ask for the rest of those documents for you to turn over. That's what should have happened. That is not what happened. What happened is the IRS went to Coinbase and said, turn over 100,000 records, or I don't remember the exact number, but it was a large number. Something on that order of magnitude. And Coinbase said, we're not going to do that. And they fought it a little bit in the court, and it went to court. Again, the people whose records were involved here weren't notified that this was happening. So their only protection was from the broker that they had deposited their cryptocurrency with. And so the judge said, well, IRS, I'm not going to let you have 100,000 records, but I'll tell you what, I'll let you have about 14,000 records. And so all those records, including our client, Mr. Harper's records, were turned over to the government. Well, our client had declared his cryptocurrency. He had paid his taxes. And the thing about cryptocurrency in particular, Jim, as you may know, once the government has your key, your blockchain key, once it knows your identity, it's not just a matter of being able to track all of your past transactions. It can track all of your future transactions because they're all public in the blockchain. And so turning over all those records to the government is a complete and utter destruction of people's financial privacy. And so we thought that was pretty significant. And unfortunately, we were not successful in convincing the federal courts of that, and we're not successful in convincing the Supreme Court to take the case. But it's something that we're going to stick with, and it's an example of the kind of Fourth Amendment rights that we're trying to secure for Americans.
And now that crypto legislation passed, it may be more important for courts to deal with it now because there's some clarity in that. But what's interesting is the process you just described sounds to me a whole lot like some PowerPoint presentations that a guy named Edward Snowden shared with a guy named Glenn Greenwald. Does this seem familiar to you?
Well, I don't know that case well enough to analogize it to the Harper
just
case.
Mass collection. I mean, in other words, now this was more confined, obviously, but any type of mass collection where people don't know that their information is being collected and then being used, which is exactly what the government was doing under the process that Edward Snowden described. We're gathering up the information. Hey, we're not taking any one person's information. We're going to go into it if we find this or that thing because we want to try to find some foreign agent, which, oh, by the way, now turns into trying to find citizens. And this is a clear violation. That type of process should be absolutely never undertaken to try to find information. It is up to the investigators to figure it out on their own. We are not subject to them as they gather that information. They are subject to what they can find out based on the facts.
And we're not subjects, we're citizens.
Correct.
And that means we have rights, and they have to prove that we did something wrong. We don't have to prove our innocence. That's not the way it's supposed to work. But that's the way it does work too often. I'll give you another example, Jim, that might be the most important case that we have going right now. We have over 30 pieces of litigation, active original litigation that NCLA has started going right now. But this is one of the most important ones, and it's a lawsuit we have against the SEC over something called the Consolidated Audit Trail. Before your audience tunes out and decides this isn't an exciting topic, let me tell you that what the SEC has done is collected the stock transaction information of over 150 million Americans. In other words, every single American who has engaged in a stock transaction in the last year, your information has been collected by the federal government without a warrant. And it's worse than that, Jim. Congress never authorized this. There was never a law passed by Congress to authorize this. This is something that the SEC under Barack Obama cooked up back in 2010 after the flash crash. And they decided, well, we really need more. We need to have more transparency into what's happening in the markets so that we can explain these phenomenon or put a quick stop to things like the flash crash sooner. And by the way, it'd sure be handy to be able to track insider trading. And if we had everybody's stock transactions in real time, I bet we could find some insider trading. And you know what? I'll tell you what, Jim, it probably does make it easier to find criminal behavior.
Oh, absolutely.
But, so would turning over all of our emails to the government make it easier for them to, I mean, that doesn't mean that the government has a right to that information. And so, we have filed a lawsuit in Texas against the SEC and FINRA and CAT LLC because we think there's a tremendous Fourth Amendment problem here. Plus, and this gets back to category 2 that we were talking about, there's no statutory authorization at all for the SEC and FINRA to do this. Now,
and FINRA is the Financial Services Regulatory Agency, just so people know. Yeah. Yep,
that's exactly right. Yep. And so the way that the SEC decided to proceed is they said, well, we're going to create this database, and then we're going to pay for the database. We're going to charge all the broker-dealers. And so effectively, and what do you think the broker-dealers are going to do? Well, of course, they're going to pass their costs on to the customers. So Congress has never authorized this. Congress has never passed a dime to pay for this database. And yet you've got a federal agency that has created probably the largest database in the federal government this side of the National Security Agency.
Right.
I mean, maybe Social Security database, something like that might be. But you're
actually, the Social Security database would be larger because you got future recipients, not just current ones, because we all have our Social Security number. But you're right. It's got to be the largest database outside of that anywhere in the country. Huge database,
which, by the way, giant juicy target for Chinese hackers or other hackers. And you've got all of your sort of retirement benefit information in there. So someone could, who was a malicious actor could go in and start messing with your retirement security based on getting in there. And so that's, like I say, one of our most important cases. Now, I've got a little bit of good news for your audience. Within the last week, there was a decision that came down from the U.S. Court of Appeals for the 11th Circuit. This is the Court of Appeals that oversees Alabama, Georgia, and Florida. And the ASA, the American Securities Association, had sued the SEC over this same Consolidated Audit Trail. But they had a narrower complaint, and their complaint was essentially that the way that the broker dealers were being charged for funding this thing was arbitrary and capricious and unlawful. And they won.
Let's just emphasize the unlawful, since there was no authorization given to them to even do that. So
Right. And so but the good news is they won. The 11th Circuit sided with those folks and said, yeah, this is arbitrary and capricious, and this is no way to run a railroad, and you can't fund it this way. And so that's great. Now, that doesn't get rid of it completely, and so our lawsuit is going to continue, and we need the current leadership at the SEC to side with us on this. And I am cautiously optimistic. I'm a big fan of Chairman Podkins. I think he's a great guy. Pastor Peirce, who's been on the commission for a while, has been loud about her opposition to the CAT. And I'm blanking on the third Republican commissioner's name. Is it Ueda? I'm not sure. But anyway, I cannot
remember. Yeah, Peirce also is good on cryptocurrency, but there is real hope in the Trump administration because there's a real focus on these things. And by the way, and so to respect our time, I want to get to 5, 6, and 7 real quick, and then get to a couple other items. But one question I have for you as it comes to this, because really it is an illegal action. So here's a question for you. We've had a lot of discussion in recent years, as the whole anti-cop movement in Democrats has happened, about an issue called qualified immunity for police officers. Yeah. And what qualified immunity allows is for them to do their function without being subject to civil or civil lawsuits against them. Those civil lawsuits go to the police agency or the city or state or whatever that funds that agency instead of directly to the officer. And there's probably a really good argument for that. By the way, I think there are arguments to modify that system, but I don't want to get into that here. People don't know qualified immunity also applies to people in the administrative state. And they also are not subject to civil fines when they act now they're subject to criminal penalties where they apply, but those are typically for administrative officials far reduced from what your average citizen doing something similar in the private sector would be subject to in civil or criminal penalties. And that's one issue, but there are laws that on criminal penalties, but civil penalties go directly to the administrative state and not to the individual. It's my opinion that we should get rid of qualified immunity for administrative officials. And again, I understand some arguments where you might push back on that, but most of those can be adjudicated when you say, well, my boss told me to do it, and you can prove very practically that happened.
Right. I was operating within the scope of my employment.
And scope of employment, but qualified immunity goes beyond a scope of employment argument. It goes much broader than that. It is a literal shield. Is it your opinion, like mine, potentially, that we need to get rid of that shield and then leave it to issues like, the administrative bubble and how you deal with that, which would apply in the private sector as well, too, FYI.
Yeah, I agree with you 100%, Jim. And I would just point out a couple things. First of all, that qualified immunity really only is, the way that you're describing it, is in place at the federal level. At the state level, we have something called Section 1983 litigation. So Congress has passed a law that says if a state official has deprived you of your federal constitutional rights, of your civil liberties, you can sue them under Section 1983 for deprivation of your civil rights. And you can even get money damages from state officials who do this. There is no equivalent cause of action against federal officials who violate your federal constitutional rights. And as a result, there's no way to come after them when they are guilty of the same kinds of things that state officials might be guilty of. And so that's problem one. Problem two, as you're talking about the qualified immunity, we have actually filed a cert petition with the Supreme Court. We have filed amicus briefs in other cases at the Supreme Court, encouraging them to draw exactly the kind of distinction that you were hinting at, Jim, which is, I think qualified immunity makes some sense if you're talking about a police officer in the field who has to make real-time life or death decisions. They're in the line of fire. They're having to they don't have time to go consult a lawyer about the constitutionality of the particular action that they're getting ready to take. Okay, well, that might make some sense. But bureaucrats, Jim, have all the time in the world to go consult the lawyers at the agency to find out whether or not, they can go get this warrant or don't have to get a warrant or, whatever the issues might be.
And they take all the time that they want to take the action that they decide to do. In other words, it's one thing to try to figure out how to react. It's another thing to act.
Yeah.
And the police officer has to act with judgment under stress, even though police officers should be better at handling stress than others. I grant that, but it's still stress. And sometimes the decisions are not very clear. But an administrative actor considers what they want to do. And we do know more and more increasingly, particularly under the censorship industrial complex, more and more increasingly with some political motive, or even maybe not a political one, but some motive for harm to someone that they don't like. Yeah. They consider that action, often take it privately where no one can see. FOIA requests. Let's look at a FOIA request. It's really hard to discern the motive sometimes because they won't give you the information to show it. But then when there's a reaction to it, they can take further action and make it even worse. And there is plenty of time to work through that.
That's right. And so that's why we think that qualified immunity shouldn't exist for those desk job folks. I think that's a good point. Back to the categories real quick. I mean, I think we pretty much already talked about number 5. That's the due process rights around these adjudications and making sure that you can get into court. Now, the one thing we didn't talk about was jury trial rights and the fact that the day before the Chevron or the Loper Bright and Relentless decision came down, getting rid of 40 years of Chevron deference, there was a case called Jarkissi v. SEC or SEC v. Jarkissi, and the Supreme Court decided that. And there's something called the public rights doctrine that has been very abused, particularly over the last half century or so, where it had gotten to the point where if Congress created a new statutory regime and then created an agency or gave responsibility for that statutory thing to an agency, and they said, well, then you can just do that enforcement within your agency. You don't have to go to federal court. Well, first of all, that's a misunderstanding of the way that public rights have worked. Traditionally, if it was a public benefit, veterans benefits, Social Security benefits, that kind of thing, you don't necessarily have to go to federal court for that because you don't have the same sort of right to those benefits. And if the government wants to adjudicate those benefits within the executive branch, that's fine. But if you're talking about the government coming after you with an enforcement action where there's going to be fines or there's going to be other ramifications for your conduct, that has to be in a real Article III court, not in a tribunal, yeah. And you have to have access to a jury. And so that's what the court decided in that case. Big decision, because that really is going to put the screws to the administrative agencies that have been trying to do all this sort of adjudication within their own agencies. Last 2 categories real quick. The 6th one is what we call guidance abuse. And so agencies sometimes will issue guidance and then try to pretend that that's binding or treat your failure to follow guidance as having some sort of ramifications, which it shouldn't have because it's not a law, it's not a rule, it's just guidance. And so that they shouldn't treat that as binding. And then the last category is conditions on spending. And this is where agencies are tasked by Congress with doling out money for something, say like the CHIPS Act, where they're trying to incentivize the building of microchip factories in the United States. And then the Department of Commerce, in that case, or whatever agency's been given this pot of money, attaches non-statutory conditions to the money. In other words, things that strings Congress didn't attach to the money, the agency attaches. And in the case of the CHIPS Act, the agency attached a bunch of climate change strings to the money. You have to use solar power in order to generate power for the plant. You have to have a child care facility within the plant in order to get this money. Well, Congress didn't pass any of that. Those are all non-statutory conditions on spending. And that's a way of essentially evading the Constitution's requirement that laws be passed by both houses of Congress and signed by the president, these non-statutory conditions. So we're pushing back against those as well.
We could have a long discussion on Article 1, Section 8 of the Constitution, which is a lot of people don't know that the Constitution is a charter of negative rights.
Yeah.
It's not a charter of positive rights. The positive rights lay with the people. That's why it starts with we the people out of our status of having positive rights are laying these negative rights upon you. Article 1, Section 8 being the limitations on what Congress can do. And as I maintain, probably anywhere between 50 and 70% of what the federal government spends is unconstitutional already every single year on an Article 1, Section 8 analysis.
Yeah.
So so we can spend a lot of time on that. But I have this one question as you're talking about those misuses of funds that don't have specific congressional authorization.
Yeah.
Is it constitutional for the federal government, for Congress to authorize spending that leads to waste, fraud, and abuse?
Well, I mean, I think that there could be waste, fraud, and abuse with any spending that Congress authorizes. So,
sure. And we are talking about a human institution. I get that.
Yeah.
But when we look at some of these programs that are being cut, particularly USAID stuff, for example, I'll just use that as an example.
Well,
there's very real, probably in the private sector, criminal fraud that takes place. Certainly some criminal abuse. And waste is a function of human error, but it also could be purposefully wasted. So That's what I'm saying. In those areas where you've really found where the executive branch has found in some program, very real, purposeful fraud and abuse, for example, every bit of Medicaid money that's being spent on an illegal alien is fraud because there's no authorization to spend any federal welfare money of any sort in any non-discretionary program. There's no authorization anywhere for people who are non-citizens to take advantage of that. So may Congress authorize that spending, and B, does that not authorize the executive branch to refuse to spend it if they find the real fraud and document it and deal with it?
Well, I think if the executive branch identifies fraudulent spending that's taking place, that it should pull back on that spending at least until such time as it can prevent that fraud from continuing. So it's not so much a refusal to spend the money; it's a break. It's a saying, well, wait a minute, we're going to fix this program before we send more money down this rat hole. So I think that's fairly defensible. Where we've gotten into a problem in this country is there seems to be a belief that there's a general spending power of Congress, that that the Constitution has a spending clause that allows the Congress to spend money on whatever it wants to, and that's really not the case. I mean, first of all, there's this concept of spending for the general welfare, which means that Congress should have to spend for things that help everybody, not sort of special interest group spending. That's that's one problem that we have. But even aside from that, Jim, you started to mention Article 1, Section 8, which is all the sort of the headings of the kinds of legislative power that Congress is authorized to have. Well, that should also be the limits on the places where it can spend money, is the places where it has the power to regulate. We have a whole lot of spending that's taking place outside of those limits. But that's really not what I'm talking about when I talk about our conditions on spending litigation. We're not focused on the problem of Congress at NCLA. We're focused on the problem of the administrative agencies. So what are the things that the administrative agencies are doing that they're not allowed to do? And so putting these strings on money that Congress has appropriated is what we're going after there.
No, I agree. And the reason I bring it up is because of the executive function, which is, I think the president's duty bound to stop waste, fraud, and abuse where it can be found, for example. And you have Congress, many people in Congress saying, no, we authorize that money. You have to go ahead and spend it. And I would say, well, no, I don't think Congress had that authorization. So therefore, on the positive end of what you're talking about, the executive branch would have the authority to stop spending money, as you said, preempting a new agency's efforts or a current agency's efforts under a new appropriation. I think the executive branch has that authority as well too. Would I be correct in that?
I think it's a little tricky, Jim. I think that, so for example, the president has a duty under the Constitution to take care that the laws are faithfully executed. Well, I think on the one hand, faithful execution means that the money is spent for the program that Congress directed the money to be spent for. But if the money is not being spent on that because it's being wasted or there's fraud, well, then you would think that part of the faithful execution would be to make sure that that waste and fraud didn't take place. But at the same time, the money isn't spent on that program at all. That's probably not faithful execution either. And so where is that line, I think, is a little tougher. But, I know the president has been interested in shutting down the Department of Education, for example, or some of the other departments, and he can't do that on his own. He needs to go to Congress. He's got both houses of Congress controlled by the Republican Party. He needs to get Congress to agree to some of those things that he wants to do, and not just shut them down, unilaterally on his own.
Yeah, and that's a good segue as we get closer and closer to time to the Boyle v. Trump case, because a lot of what you're discussing and most of the approach he's taken with the Department of Education has been related to numbers of employees and who are going to continue. Of course, there were a couple big cases out there where he had actually furloughed or let certain employees go. And you had judicial restrictions on whether he could do that. So talk about Boyle v. Trump, and first of all, set people up with what it is.
Yeah.
And then talk about this issue of what the president can do with employees.
So there's a series of cases. So Boyle v. Trump involves three Democrat commissioners, former Democrat commissioners at the Consumer Product Safety Commission. Mary Boyle is the one who's sort of the named plaintiff on that lawsuit. But it also includes Richard Trumka and Alex Hohn-Sarich, the former chairman of the CPSC, and the president fired them. And his position is that these are principal officers of the United States. I run the executive branch, and I can remove these principal officers. And their view was that, well, wait a minute, these are independent agencies that Congress set up, and as independent agencies, the president can't fire us except for cause. Like he has to show that we have neglected our duty or done something else that would justify our firing. He can't just fire us for any reason. Well, the CPSC is interesting too, Jim, because think about it for just a minute. Why are there 3 Democrats and only 2 Republicans at a federal agency when there's a Republican president? In other words, the Democrats were controlling the agenda of the agency. Well, that's reason enough for the president to fire at least 1 or 2 of them. I mean, you need to have the independent agency. Independent of what? Independent of who? Independent of the president? No, that's not.
It's in the executive branch. Nothing's independent of the president.
It's not supposed to be independent of the president. That's not the way that these agencies are supposed to work. And so this case worked up to the Supreme Court on a stay issue, and because the lower courts had the president fired them. The lower courts had ruled that they had to let these commissioners back onto the commission and give them access to everything, and the commissioners were busy undoing all the stuff that had happened while they had been fired, and it was a complete mess, complete chaos. And I know I used to be at the CPSC, so I have some sources at the commission telling me how much of chaos was on the scene over there. Well, so the Supreme Court stepped in and they said, well, actually, the president, it's going to be more of a problem to have those people who the president doesn't want in power to continue in power than it would be for them to stop serving. So therefore, we're not going to stay the president's hand. Those people are gone from the commission. Now they can keep their lawsuit going. They can sue for back wages. There's other things that they can do, but they're not going to be serving on the commission as long as that's in effect. And there have been some other decisions too, right? There was the Dellinger decision where the head of the Office of Special Counsel at the Department of Justice, a guy named Hunter Dellinger, I think it is, was trying to hang on to his office, and the U.S. Court of Appeals for the D.C. Circuit said, no, you're a principal officer. The president wants to remove you. He can remove you. And it's not possible for a district judge to put you back in office. There's the Trump v. Wilcox case was someone, there are 2 different people. One was from the National Labor Relations Board. We were talking about that earlier. The other was from another agency called the Merit Systems Protection Board, which oversees the civil service and who can be fired in the civil service. The president fired those people, and they also sued to try to get their jobs back. And those cases are continuing as well. But I think what we're going to find, Jim, is that, and this is NCLA's position, the president has the ability to control the principal officers in the executive branch, and that includes people at these independent agencies. There's a decision from the 1930s called Humphrey's Executor that said that President Roosevelt couldn't fire he'd already fired Mr. Humphreys, and then Mr. Humphreys died, which is why it was Humphrey's executor who was seeking back pay. But the upshot of the case was that the Supreme Court decided that the FTC, as of the mid-1930s, was exercising quasi-legislative and quasi-judicial power, but wasn't exercising executive power. Therefore, therefore, the president couldn't fire those people. Well, I don't think that was true in the mid-1930s. I think it was, that there was some executive power going on back then too. Even if there wasn't then, there's definitely executive power occurring today at the FTC, at the NLRB, at the CPSC, all these agencies. So the president needs to be able to control the executive power because there's only one president, and he needs to be able to fire the principal officers at these agencies across the executive branch. And that's what the Supreme Court will eventually hold, I believe.
Well, and we're not going to get to our couple tricky issues, which I hope we can come back and do sometime here in the near future if you get a chance. But I do want to ask you about this because it's another related but different type of federal appointee employee. What's your judgment on what's happening with the situation with U.S. attorneys right now, and what do we need to know about that? Because that's a different thing. That's the appointment power as opposed to having the administrative. Exactly. So tell me what's going on there and what you guys are doing with it.
Well, the president's appointment power is far more constrained in the Constitution than his removal power. So, for example, he can't typically appoint people without the advice and consent of the Senate to a lot of these principal positions, cabinet agencies, and so forth. Traditionally, the U.S. attorneys, which are the lead prosecutors in the 94 federal districts around the country, those folks have traditionally been appointed by the president and confirmed by the Senate. But Congress had passed a statute a number of decades ago that said that if the person, so when the president first comes into office and he appoints these U.S. attorneys, a lot of times there's a person who's acting in that capacity because they haven't been confirmed by the Senate yet. And so they're just an acting U.S. attorney, and they can only do that for a statutorily specified period of time. I think it's 120 days or it might be 180 days, but whatever it is, there's a limited number of amount of time that they can serve. Well, Congress said, well, look, at the end of that period of time, if the person that the president has appointed still hasn't been confirmed by the Senate, then the district judges of that district can appoint someone to be the acting U.S. attorney. And in many cases, historically, they've just taken the person that the president already had in that position, and they've said, okay, we'll have that person continue to serve. Well, right. The odd thing that's happened during the Trump administration is that in a couple of high-profile examples, including New Jersey, the district judges have said, no, we're not going to appoint the person that the president has wanted to be in this position. In fact, we're going to appoint someone else, maybe someone who's a Democrat, to this position. I think it's a real problem, Jim. I know the statute's been around a long time, and sometimes judges are unwilling to overturn statutes that have been on the books for a long period of time. I will point out that Congress repealed that law back during the Bush administration around 2005 or so, but then it was put back into place just a couple of years later. So the problem, from my perspective, there are precedents suggesting that. Well, there's a provision in the Constitution. Folks can go find it. It's right. The text is right in the Constitution. Congress can, by law, give appointment power to the president, to the courts of law, or to the heads of departments. So those are sort of three different places. So in this case, what they would say is, well, we've given under certain circumstances the appointment power over U.S. attorneys to the courts of law. But there's two problems with that. First of all, it says inferior officers. So not principal officers, inferior officers. Well, are U.S. attorneys principal officers or inferior officers? Traditionally, they've been thought of as inferior officers, but I think that's wrong. I actually think U.S. attorneys are principal officers. They have way too much power to be thought of as inferior officers, in my view. And so that's one place that you might argue that there's a problem with what the district judges are doing. I admit that the precedent is currently against us on that, but I think that's an important point to make. The second problem, though, Jim, I don't think that the Constitution was talking about one branch appointing officers in another branch. I think what the Constitution had in mind was that Congress could, by law, have the judges appoint people within the judicial branch. So the federal judges can appoint their own clerks. The federal judges can appoint the clerk of the Supreme Court. The federal judges can appoint people to run the administration of the courts. Likewise, the heads of departments can appoint their, the chairman of an agency or the secretary of a cabinet department can appoint their deputies if Congress has assigned them that ability. It's not that. I mean, think of it this way. Do you think that the Secretary of the Treasury can appoint Chief Justice Roberts' law clerks?
Right.
I mean, even if Congress passed a law saying that would be bizarre. Yeah. But that's essentially what's happening here is you've got the district judges appointing the president's U.S. attorneys in the Department of Justice. I think that statute is ill-conceived, and I think that the Constitution has been misconstrued. And so, we'll see how that gets litigated. And by the way, is that really legislative power to leave that off to the judicial branch? I don't know. There's just a lot of questions there. A lot of questions there, and I think it's one of those things that maybe doesn't get attention until you have something strange happen, like what has happened with the president's temporary appointees this year. Absolutely. Well, so before we close, I want to get your general assessment on a couple things, just briefly, but to close down on that point, we have in this country, and I think mostly successfully so, in our first 150 years at least, left people who are in not just elective office, but in administrative positions to have a good conscience and to do things in a way that is consistent with the Constitution. That's why we ask them to take an oath to the Constitution. Every person throughout the executive branch has to take that oath, as well as the president himself. So we've kind of relied on that, or at least our instinct. Well, we did very purposefully rely on that in our first 100 years. But as you crept into the 150th year and beyond, we were just, we felt that the instinct was there to do that. Yeah. In the last 100 years, I'd say that instinct is all that exists, and we don't even think specifically about what's actually happening. And that's why that's, first of all, the need for your organization, because we've slipped so far away. We're only mere instinct and then assumption of that someone will do well just because they're in that position. And that just doesn't happen. Or Jim, we've trusted that having the right person is enough. And I think that sometimes when we have the wrong processes in place, or we have bad habits at these agencies where they're not respecting people's civil liberties, then having a good person at the top of the agency isn't enough. You also need to reform the practices, the lack of jury trials, et cetera, that are happening with those agencies. And that's just added to going by mere instinct and belief as opposed to practical. And that practical thing actually did save us from a lot of problems. I mean, just take the Bank of the United States as a great example. Marbury B. Madison, even though I disagree with the opinion, but or in some cases, but we were addressing those potential harms directly in our litigation when it still existed in the past. Now, there's so much political litigation, and there's some very real and useful litigation, of course, but there's so much of it that gets targeted in a political sense, notwithstanding the fact that we've given powers where they don't exist. This is a real problem. We're in a major moral hazard. So my final question to you is, what do you think our situation is now, both in terms of Trump becoming president and in terms of just where we are right now? Do we have some hope of reining this in? Because to be candid, the administrative state is so large. I mean, it is the deep state, and I don't only mean that in terms of the intelligence community and what they do, but really they are a state unto themselves in so many ways. Is it even possible to pare that back? What's the situation now? Is it possible to pare it back? Well, I'll tell you what, Jim, I'm a lot more optimistic now than I was 8 years ago when Philip Hamburger hired me to run the new Civil Liberties Alliance. And I think that the success that this organization has had in, first of all, driving awareness to the problems of the administrative state. Second of all, the one silver lining, if I can put it that way, of the horrific COVID-19 pandemic that we had is that all of us, every single American, got to witness what rule by administrative power looked like, and I don't think they liked it very much. And so, I think that was a rude awakening for a lot of folks that said, "Well, wait a minute, maybe we've gone too far down the road here of having executive power rather than having our legislatures decide things." And so, I think that folks are starting to claw some of that back. And then our victories in court, Jim, have been really fantastic victories, whether you're talking about the Chevron overturning 40 years of judicial deference doctrines with our relentless victory over Chevron deference. If you're talking about bureaucracy and restoring the ability to have jury trials, if you're talking about, I could go down a list of cases that we haven't even talked about, but we've had enough of these successes against the administrative state in court that I believe that we can get back. Now, can we get all the way back to where you want to be or where I want to be? Oh, that's a tall order. But I think that we can definitely make further progress. Humphrey's executor, I think, is going to be the next precedent to go. It's going to restore the president's control over these executive branch appointments and removals, and so that's good. And there are other things like that we can do to make sure that our system gets back to the system of self-government that our founders created for us, right? It was Benjamin Franklin who said, we've given you a republic if you can keep it. Well, for the last 50 years, we've done a pretty lousy job of keeping it. But I think we can reverse a lot of the damage, and the new Civil Liberties Alliance is here to make sure that happens. And I would welcome people to go to our website, nclalegal.org, and check out all the great litigation that we have going on and other programs that we have. And if you're interested in fighting the administrative state, then partnering with NCLA is the best way to do it.
Well, and I really encourage people to go to the nclalegal.org because they do want to find out what you're doing. There's legal stuff there, and you're thinking, well, I don't like lawyers. I don't want to. No, trust me, it's fundamental to your liberties. And in fact, we didn't dig into how significant the Chevron case was, and my apologies for that. But the Chevron case does, as we were talking earlier about people's ability to go to court when they've been wronged by government. And there are many aspects of what happens in the federal government where now that can happen, particularly corporations, and usually small and mid-sized businesses that find themselves overwhelmed by federal executive power now have much more flexibility to get something done. And then for future things, and tell me if I'm wrong on this, but I think the fact, as critical as I've been of John Roberts as Chief Justice of the Supreme Court, this is one of the areas where he actually is pretty darn good. Yes. One, he's a vote to get this done. And he was a vote for Chevron. He wrote pushed that a lot.
He wrote the decision.
Yeah, he wrote the decision, of course. But he was a vote for Chevron, and he probably pushed it in their private discussions.
Yeah.
And so
just to be clear, he was a vote against Chevron. He was a vote for the Loper Bright relentless cases overturning
Chevron. That's what I meant. Yeah. Again, that's right. For Loper Bright that got rid of Chevron. Yeah. But and because he gets this is one of his areas. And so we have a lot of hope that we can break down the administrative state further. Donald Trump's doing a lot of work to physically get his hands on the administrative state and move it and mold it, as he has a right to do and in Article 2, Section 1, because the executive power is in a president of the United States. That is just fundamental. And of course, we need a lot more jurisprudence to reaffirm that, but we need Donald Trump to assert it. And he is doing that in many ways and mostly positive. So we got that, but you've got that. Even I have some disagreements, but I'm generally positive. I'm very, very positive in the overall tenor of it, because even where he overreaches, the direction is moving. The change is happening in the right way. And I think finally people understand that, we do actually have a president of the United States. He's not some guy like in Texas where the governor has no power. He's not some guy that's a figurehead about the United States. No,
or a guy just sitting on a beach licking an ice cream cone.
Correct. Exactly. And so that's good. But anyway, we will have some jurisprudence around this, both to stop anything that Trump might do that goes too far on the edges, but certainly where most presidents in the modern era have entirely let this get off the wheels, I think, and then Congress has done its job too. I think we can bring that back in because we have a Supreme Court that can make some of these key decisions. And Chevron is huge. It's going to have a massive effect on the economy that we haven't yet quite seen. It comes in there. It's like slow showing up, just like getting rid of a regulation is, but it does show up.
Well, and the way I've talked about it, Jim, is it levels the playing field for all of our future litigation against the administrative state. That's really the big advantage. We're not fighting uphill battles all the time anymore now that Chevron deference has gone away.
That's great.
So our motto at NCLA is let judges judge, let legislators legislate, and don't let bureaucrats do either. And so, we're going to have a lot more success with that now that Chevron deference is out of the way.
Yeah, for all the overreach that we truly do see in our court system right now, and it is there, the overreach that's really killing us most is happening every day in the executive branch. And you are right. You're not allowed to legislate or adjudicate. Well, with that, we could spend a lot of time, and one time we will. But Mark Chenoweth is president of the new Civil Liberties Alliance, NCLAlegal.org. You definitely need to go visit that website. Definitely be involved there. I know that where we through the Conservative Caucus will have a need to do so, you and I'll be locking arms. We've been good friends for a long period of time, and Mark's someone I have a deep amount of trust and belief in his capabilities. And
well, I appreciate that. I appreciate that, Jim, very much. And we have lots of videos too at our, not just at our on our website, but our YouTube channel, our X channel, so people can check out the videos too. If they want to read the briefs, that's great. But if you're not somebody who enjoys reading legal briefs, there's lots of great case videos and that kind of thing for people to check out too.
That would be extremely helpful for people who want to try to figure out some of these more thorny legal issues that they're not thinking about every day because they're not lawyers. So that I would definitely encourage that. Again, NCLAlegal.org. Make sure you go there. Mark, thanks for doing the podcast with me today. And we'll definitely try to do this again soon here in some weeks or months ahead.
Delighted to be with you, Jim. Thanks for the invitation.
Thanks for joining us at the Conservative Caucus podcast and my discussion with Mark Chenoweth. I think you have found actually that this is just an amazing and important part of what is going on in our lives. Reforms that are taking place that I think are going to be beneficial to all Americans. So thanks for joining us with that. And of course, as we're building this podcast out, I want to get your information, your ideas about people that you think that we ought to talk to. Email us at info@theconservativecaucus.com. That's info@theconservativecaucus.com. Give us your ideas, people you want us to talk to. We'll reach out to them. We'll try to make that happen. And let us know how we're doing with this podcast. Give us some feedback. It's really important to us, and we'd love to learn more from you. And of course, go to theconservativecaucus.com. You can find out information about the organization that I run, and you can get involved with us in various ways. You can find out more at theconservativecaucus.com. And of course, follow us on X and Truth Social and Facebook and many other platforms. You can find out how to get there by going to theconservativecaucus.com. Thanks for joining us today.